All right, Madam Officer, will you open the court for me, please?
The State of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning.
Good morning.
We are on the record calling for objection to garnishment, case number 191444146, Bright Financial Service versus Rory Huff. Could I have your respective appearances?
Good morning, Your Honor. Robert Goodman on behalf of the plaintiff. My P number is 55670.
Your name, sir.
Good morning, Rory Huff.
Sir, you are the moving party. What is the basis of your objection to garnishment?
Yes, Your Honor. Thanks for having me this morning. My basis is first and foremost, I never was summoned or served in reference to this matter. They had in the court, and I guess the attorney had the wrong apartment number. I lived and I faxed over proof of the address, but I lived at 1554 Franklin, apartment 302 in Detroit, Michigan. And they, I guess, served apartment 304. And that's what, I guess, when I called the court, the address that they had in the system. So it was a totally different address than mine. So I was never aware of this matter to even, appear in court on the day back, I guess, in 2019. And then when I got alerted to it was when, they garnished my bank account. And when I was reading some of the ways that I could object, one of the reasons was never been served, as well as if I was currently on unemployment. And currently, based on the COVID-19 and some of the things that's going on, I'm currently on unemployment, and I faxed over proof of that as well. So hopefully you received that document where it states that, I'm currently on unemployment. So, I'm really, praying that I can get this money recouped. And then the third thing was I was disputing even the validity of the money that Bright Financial said that I owed, because on my contract, I signed up for something called loss of job protection, where I can voluntarily turn the vehicle. I had like a 2013 Ford Taurus, and I turned the vehicle in voluntarily back to Bright Financial. They waived the money that I owed as far as the remaining balance on the vehicle, but they said I owed extra money for mileage, which I was disputing. And I called the attorney and, formally asked for a copy of my contract, as well as documentation showing the breakdown of the loss of job protection. And he rejected, me from getting those documents. So I wasn't able to retrieve it. But pretty much those three things are the reasoning that I was objecting. Yeah.
All right. Let me ask the question again, just so my notes are clear. Where do you say you lived on Franklin? Which apartment number?
302.
Okay.
Yep.
302.
Yes, sir.
Let's hear from Mr. Goodman.
Yes, Your Honor. So with respect to the objection to garnishment, whenever we receive an objection claiming exempt funds, we immediately subpoena from the bank records so that we can look and identify the source of funds. Obviously, when we file a garnishment, we don't know what the source of funds are in there. The bank will do a look themselves and make sure that they are not attaching any Social Security money, unemployment benefits. And so the reason why the bank attached the $2,000 in this case is because there are various deposits in here other than unemployment benefits. There's continuous deposits from Elder Ford, as well. And I provided a supplement to the court. I hope that the court has it in its file with the bank records, but there's clearly other sources of income other than unemployment benefits, which is why the bank attached the money. With respect to his challenging of the underlying judgment and the address, I can only indicate, Your Honor, that we attempted service. We were unable to obtain personal service. We had filed a motion for alternative service, provided to the court a postal verification, which the post office confirmed that was the correct address. And then the process server had listed his attempts. With that, an order for alt service was signed. We submitted, we effectuated service of process pursuant to that order for alt service. And then a judgment was ultimately entered. A default judgment was ultimately entered. I will indicate to the court that we've had communications with Mr. Huff going back to July of 2000. At that time, we discussed the account. He had made a settlement offer. We had went to our client who rejected it. And then ultimately, we had agreed on a settlement amount, and he agreed on it, and he just never made the settlement payment. And that was on July 16th of 2020. So he's at least known about this case going as far back as July 16th of 2020. And furthermore, this is an objection to garnishment. It's really not the appropriate motion to challenge the underlying judgment. And that's the position of the plaintiff.
All right. Is there anything else you want to tell me, Mr. Huff?
Well, yeah. When he said that they had communication with me in July 2020, that was a situation where I seen that on my credit report that I had a $2,000 balance with Bright Financial, and then that's when I reached out to try to settle, or I was disputing it, and they wouldn't budge on the amount to try and do a settlement amount, and that's when I was first alerted to this creditor and this debt that they said I owed, but I wasn't alerted in, I think they said 2019. So it looks like May 15th, 2019, when the judgment was entered for 2199.82. Like I said, I never had an opportunity to come to court and, state my case like I'm able to do today because they never served the correct address.
All right, the court's prepared to rule this matter. Thank you. There are basically two issues here. The first question, Mr. Huff, is your challenge to the validity of the underlying judgment, saying that you were never served. Michigan Court Rule 3.101K is very specific here. You may not use the objection to garnishment form to challenge the validity of the judgment that was entered against you. You did not file a motion to challenge that judgment. You may not do so by way of objection to garnishment. Further, I would point to you parenthetically, and this is parenthetical simply because I'm just telling you understand what I understand the case to be. Your claim that you lived in apartment 302 is contrary to the postal verification, which was provided by the United States Post Office dated January 30th, 2019, which said you lived at the Franklin address in apartment 304. In any event, because you may not use an objection to garnishment to challenge the validity of the underlying judgment, that aspect of your claim must be rejected. The remaining claim is that you had exempt funds, that is, funds that were from unemployment or Social Security that were garnished. The information that was provided to the bank, by the bank, or should I say, and then by Mr. Goodman, indicated that you had funds in that account other than funds that came from unemployment or Social Security. You had funds coming in on a regular basis, for example, from a business. So when you mix exempt funds and non-exempt funds, the bank has the obligation to try to separate out what is exempt and what is not. And they did that here. That's why in the space of a judgment or for more than $2,000 in the face of an account that had a balance over $6,000, they did not attach pay the full amount of judgment. The court finds, therefore, that the funds that were taken were not exempt, that the bank had done its statutory duty and separated out funds that were exempt from funds which were not exempt from garnishment. Therefore, your motion your objection to garnishment will be denied. You, of course, sir, have an absolute right to appeal my decision. Appeal must be perfected within 21 days of today in the Wayne County Circuit Court. I'll enter an order denying the objection to garnishment. Thank you, gentlemen, both for coming in. We are off the record.
Thank you. Judge, do you have the proposed order that we attached to our supplement?
I'll just use the form order.
Okay. All right. Thank you, Judge. We appreciate it.
Granted, not granted, then funds to be returned. Okay,
Thank
you. Thank you, sir.
And-
All right. Mr. Varketti, what file are you here on?
Hi, good morning, Your Honor. I'm here on two files. The first is Automotive Credit Corporation versus Jacqueline Wright. And the second is Cavalry SPV LLC versus Deborah Stinson.
Okay, I have Ms. Stinson on that one. So let's get started on that file. Let's get Ms. Stinson in here. We are on the record calling for objection to garnishment, file number 101211730. Cavalry SPV versus Deborah Stinson, date and time for objection to garnishment, your respective appearances.
Good morning, Your Honor. Attorney James Varketti, P79606, appearing on behalf of the plaintiff.
And what is your name, ma'am?
Good morning, Your Honor. Deborah Stinson.
Ma'am, you are the moving party. What is the basis of your objection to garnishment?
First of all, Your Honor, I don't believe that I owe this bill because I received a 1099 from 2012 where I settled with Cavalry, and this is the document that they sent me from.
Let me stop you. A 1099 is an income tax form that is sent from a provider to an independent contractor.
Yes, sir. And so when they sent me that was to show that this bill was discharged, that I was no longer responsible for the balance because we came to a settlement agreement on this bill. So I shouldn't have to pay any additional monies because this, not only this Rosen Barsetti or the representative have tried to get money, also Buckler, this account has been through like 3 different parties. And then I received a letter in the mail from the Attorney General talking about how these predators, people are trying to get money from people that owe money. But my TRW will reflect that there's no money owed on my TRW because I pulled my credit report and there's nothing on there from Cavalry or anybody saying I still owe them.
Okay, this 1099 that you're referencing, what is the date of it?
10/25/2012.
2012.
Yes,
Okay.
sir.
Anything else you want to tell me?
Yes, sir. Also, I received a letter from this Rosen Barsetti company. They're representing the Cavalry company, and I was wanting to know. Okay, I have been sending them money to them prior to that. And then they're saying that I had not paid them any money. And I did, and I have. And I didn't understand. So when I thought about it, because I had been going through a lot at the time that I was going through a transition period where, yes, I did owe money, but I was in such, I was just kind of stressed out at the time, dealing with a lot of sickness in the family and stuff like that. So I just wanted to make an agreement to make payments or whatever. And so when I finally get a chance to go through my paperwork and stuff, and I see where I'm like, I don't even owe them. Then I have another letter here that I received, but it's from a different company. At the same time, when I was going through this with this Cavalry company, where my bill was paid off, and they did send me a letter saying that they had closed the files and that I didn't owe them anything. And that letter was dated May 3rd, 2012. So that's why I say, yes, I was in debt at that time and I was going through a lot. And I do have proof to show that I did receive 1099s, showing that I tried to make settlements with these companies, settle with them, and therefore, as a result, I guess whatever the balance was, they discharged or written off or whatever, they sent me the 1099s form for. So why do I have to pay double, whereas I've claimed this money on my income tax, and then now this Rosen company, law firm, Butler and Buckler, they have tried to get money from me as well. So I've been sending money to these different companies. I guess they sold it over to this new company. And so why do I have to keep paying out money for something that I don't owe?
Your response.
Good morning, Your Honor. I'm not aware of any 1099 being sent or any settlement. So I can't
I
speak to
have
that
it right
because
here.
Excuse me, ma'am. He gets to speak interrupted just like.
Okay, I'm sorry. You're right. I'm sorry.
I'm not aware of any. I certainly wish that this were an in-court appearance so I could actually take a look at it and examine it. But I'm not aware of any settlement agreement or any 1099 being sent out several years ago. To the best of my knowledge, there was still a judgment on this file with a balance, which is why we filed a tax garnishment. The objection that was stated on the defendant's objection to garnishment was that she didn't receive notice. We typically do send out the notice via first-class mail to the address on file, and the Treasury Department generally sends a disclosure. So I would suggest that the defendant did have notice of the tax garnishment. So I would request that the objection be denied, or in the alternative that the defendant provide us with this 1099 and the settlement letter so that we can at least take it back to our client to verify whether there was any settlement or not. Because again, I'm not aware of any, and I don't see any in our paperwork.
Okay. I've got to make a decision on the file today. Ms. Stinson, I'm looking at your objection to garnishment. I have not received any notice of garnishment from Michigan Department of Treasury and the plaintiffs and its attorneys that was filed in August 2020. A couple of things. Michigan Court Rule 3.101K says you may not use the objection to garnishment, which is the only matter before the court today, to challenge the validity of the underlying judgment. You may not say that there was something, these judgments have been paid off and I should not have had a judgment against you. You cannot do that in objection to garnishment. You cannot use the objection to garnishment to challenge the validity of the judgment that was entered. You say you got 1099s in 2012. It appears that the judgment by default was entered against you back in January of 2011. By way of your not getting notice of the garnishment prior to its occurring, the way the process works is that the person with the judgment against you, in this case, now I think it's the Rosen office, files a writ of garnishment with the company or organization that they believe has money that belongs to you. It could be a bank, it could be a credit union, it could be the Michigan Department of Treasury. It is the obligation of that party, which is called the garnishee defendant, to do two things. The garnishee defendant here, the Secretary of the Department of Treasury, has to reply filing what's called a disclosure to the plaintiff's lawyer saying, yes, I have money that belongs to Ms. Stinson, or no, I do not. It is also the obligation of the garnishee defendant to notify you that you have been garnished. That is not the statutory obligation of the plaintiff. You have failed to state a valid objection to garnishment. Your objection to garnishment must therefore be denied. You, of course, have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. The court will send out an order to both of you, and thank you both for coming in. We are now off the record.
Thank you, Your Honor.
Thank you.
Your Honor.
All right. Barchetti, you had another one?
Yes, the second matter was Automotive Credit Corporation versus Jacqueline Wright.
Uh, 554. Okay. I don't see a Jacqueline Wright here. Let me see if I have a Jacqueline Wright in my waiting room. Jacqueline Wright here.
Yes.
Who's
Good morning.
Oh, you said you're F. Glenn?
Yeah, I'm on, huh?
Okay, which one of you is Jacqueline Wright? Wave for me. Okay, I see who you are. Okay, everybody else is going back then to my waiting room.
Oh.
And we'll do that file next. It's kind of misleading when your information doesn't give me your correct name. Okay, this is case number 07-136-554, Automotive Credit versus Jacqueline Wright. This is the date and time for objection to garnishment. Your respective appearances.
Good morning, Your Honor. Attorney James Varchetti, P79606, appearing on behalf of the plaintiff.
What is your name, ma'am?
Jacqueline Wright.
You are the moving party. What is the basis of your objection to garnishment?
Well, I never got any notice far as for the garnishment. I'm here in Houston. I've been in Houston for 11 years. Due to before that, I was living at the address where they said they sent stuff, but I never got anything far as a garnishment, far as anything pertaining this case until just now, March the 4th, 2021.
Do you have any other basis for your objection to garnishment?
No, sir.
Let me hear from Mr. Varchetti. Counsel?
Well, Your Honor, I would note that under the court rules MCR 3.101K, the objection to garnishment can't be used to attack the underlying judgment. There was a judgment in this file. We filed the bank garnishment. The bank has apparently notified the defendant of the garnishment. There should be no problems with notice. Therefore, I would ask that the objection be denied.
All right, Ms. Wright, let me explain something to you. First of all, let me put a couple things on the record. The judgment was entered against you on November 27th of 2007, and then renewed again on February 14th of 2017. It was not until March of 2021 that you changed your address with the court. Before that time, we had the prior address with you. In any event, your objection, excuse me, ma'am, I'm speaking.
Oh, I'm sorry.
Your objection is that you were not notified of the garnishment. The way the process works is that the party who has a judgment against you, they do not notify you of the garnishment. They go to somebody, maybe it's a credit union, maybe it's a bank, maybe it's an employer, where they believe there's some money that belongs to you. They file their writ of garnishment with that credit bureau, with that bank, with that employer. That entity is now called the garnishing defendant. It is the obligation of the garnishing defendant to do two things. Number one, they must respond to the writ of garnishment. They do that by filing what's a disclosure. And that means basically they say to the plaintiff or plaintiff's lawyer, yes, I have money that belongs to Ms. Wright, or no, I do not. And if I have money, here's the money. It is also the obligation of the garnishing defendant to let you know that you have been garnished. It is not the obligation of the plaintiff. And apparently you have been advised of that by the bank. The judgment that was entered against you on November 27th of 2007 was renewed on February 14th of 2017. Is there's a valid judgment. You have failed, therefore, to state a valid objection to garnishment. Your objection to garnishment must be denied. You, of course, ma'am, have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. I'll send you out, both of you, in order, and thank you both for coming in. We are off the record.
Thank you, Your Honor.
All right, are you done, Mr. Varchetti, or you have another one?
I am done, Your Honor. Those were the only two hearings for me today. All right.
Two, correct. Thank you.
Mr. Nathanson?
Yes, Your Honor, I am here.
What file are you here on today, sir?
I'm here on Auto Advance versus Teresa Cosley, last four digits 5303.
All right, give me just a second. Teresa Cosley, I think. Submit all.
I thought I did see her here. Oh, there she is.
Two people here.
Yes,
I'm looking for Teresa Cosley.
Teresa Cosley.
All right, who is T Light?
That was my other computer because I had them confused. I had
All right, T Light is your other phone?
that's my computer.
All right, we'll stay with your phone. Does that work for you?
Yes, sir.
All right, well, I'm going to take T Light out.
Okay.
All right, we are on the record. This is case number 19165-303, Auto Advance of America versus Teresa Cosley. This is the date and time set for an objection to garnishment, your respective appearances.
For the record, Your Honor, Keith Nathanson, P41633, appearing on behalf of the plaintiff.
And what is your name, ma'am?
Teresa Michelle Cosley.
Ma'am, you are the moving party. What is the basis of your objection to garnishment?
Because I had purchased the car. I had been laid off for a year from Chrysler. And I didn't really have the money. So I went to this little place to purchase the car, gave them what, $1,200 down, $500 for title and all of that. Basically, I could never get the car registered. And I kept calling Auto Advance. They said nothing. In other words, they was in between dealerships because something had happened. So basically, I was caught in the middle of something. So I could never get the car registered. So I asked them to come and get it. Because by that time, I had gotten another car. I worked enough to get a new car. And they came and got it like maybe about 2 months later. And then they never would repair the car because I needed the car immediately. So I kept going back, and they kept telling me that they in between switching people at the dealership or something. So basically, I just couldn't get the car registered. I took it up there, and so I was just basically beat out my money. $1,200 plus the $500 for license and tag that I never got.
Okay. Anything else you want to tell the court?
No, sir. Other than I kept trying to work it out with them about the tag, and nothing happened until eventually they did come and get it.
Mr. Nathanson.
Thank you, Your Honor. Well, the defendant's objections were that the balance of the judgment is wrong. This court entered a judgment.
Sorry to interrupt,
I
but
apologize.
you have an appointment soon.
That's my computer, Your Honor. I apologize. October 2nd of 2019. The judgment balance matches the judgment balance on the garnishment. And further, MCR 3.101 does not allow on the objections to garnishment a collateral attack on the underlying basis of the judgment. That is another matter, and that would be heard before the court, but certainly an objection to the garnishment cannot be used to attack the underlying judgment itself. We just ask the court deny it.
All right, Ms. Crossley, the only pleading before the court today that you filed an objection to garnishment. Michigan Court Rule 3.101K is quite specific here. You may not use the objection to garnishment, which is the only matter before the court, to challenge the validity of the underlying judgment. Having failed to state a valid objection to garnishment, your objection to garnishment must be denied. You, of course, ma'am, have an absolute right to appeal my decision. That appeal must be perfected in 21 days today in the Wayne County Circuit Court. Ma'am, what is it?
Yes, I did send in paperwork prior to at least in the meantime to lower the payment.
Ma'am, that's not before the court. Your objection is to the garnishment. You have to state, you as the moving party have to state a valid objection to garnishment. The only objection that you have stated is that you don't think the underlying judgment should have been entered. I'm reading from your letter. I don't think it's fair that you were having to pay for a car that I kept approximately a month or two before repeatedly requesting to pick the vehicle up. That's an attack on the underlying judgment, ma'am. Michigan Court Rule 3.101K specifically prohibits you from doing what you are attempting to do with the objection to garnishment. Having failed to state a valid objection to garnishment, that objection will be denied. You have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. Thank you both for coming in. We are off the record.
All right,
Okay, so I send it to you,
No, ma'am, it goes to the Wayne County Circuit Court.
Wayne.
I will send out a order on your file today. Thank you for coming in.
Thank you.
all right, thank you, Your Honor. Have a good day. Stay safe.
Good morning, Council. Which file is yours? Hello,
Yes,
which file is yours?
I'm here on Young Supply versus Detroit Property Improvement, and also south of Baseline versus Sharice Doe. I don't know if the court received the letter from us that we were withdrawing our creditor's exam though.
I did not in regard to Young Supply.
No, we just filed it for Sharice Doe, but I also need an adjournment on Young Supply as well, because we need about 60 days to keep trying to serve the defendant with the subpoena.
You were not able to make service?
No,
Okay, well, then I'll just call the case and dismiss it. And we try it again.
okay, so we just need to refile a whole new subpoena?
Yes, that's
Okay.
why I give you all that time. So let's
Okay.
go on the record, and I can do that and let you go right now.
Okay, perfect.
We are on the record calling case number 1817358, Young Supply Company versus Detroit Property Improvement. Your appearance, please.
Good morning, Your Honor. Jessica Notar Berardino, P83454, on behalf of the plaintiff.
And we are scheduled today for a debtor's examination of defendant Lawrence Carter. Is that correct?
Yes, correct.
And my understanding from our conversations, you are unable to serve Mr. Carter.
Yes, correct.
And what the court will do is I will dismiss today's hearing, and we'll try it again another time.
Okay, thank you.
Have a good day. We're off the record.
You too. Bye.
Oh, 358. Which one is this?
today, doesn't that take you somewhere else? To a different plane? That's pretty groovy stuff by one of the Webbers. Yeah, one of the Webbers, Anthony Weber's dad, and Bill, and the forward. And he was saying as he listened to that, you could feel that he was channeling the stuff. It was a little bit for a moment there, like mono wrote. Then he was stressed. You were full of stress for a moment. Isn't that something? And then again, no. Unique. Yeah, it was so great. So that's these are type of musical surprises that we'd like to share with you throughout the day here on WRCJ. We like to think you never know what's coming next. But one thing you can be sure of is we are going to curate the absolute best music for you and play it for you. I did a triple so you had the Renee Clinton recording, that was a new one. And then it was the Ernest Bloch piano piece, and finally the William Clinton. That's three new ones for me today. Wow, that's pretty cool listening. Yeah, I WCJ. I heard that years ago, but that's wild. Like I heard that they have a roll 866-909-975. What sort of music that you are you the type of person that likes to be surprised, even though you may be extremely knowledgeable about classical music? Well, that's what a public radio station will WRCJ can do. We can be here for you, and no matter your level of sophistication, whether you're just learning how to about classical music or starting to enjoy it, or whether you've been enjoying it for many, many years, we're here to help bring you new things along with all that you already know. 866-909-975. 866-909-9725 WRCJ FM.org. We have something coming up here about half an hour. Maybe new for you. It's the Bach Brandenburg Concerto number 7. Yeah, you heard that right, number 7. We talked about this a little while ago. It's an arrangement of some of Bach's tunes by a contemporary classical arranger into what sounds like might have been Bach's 7th Brandenburg Concerto, if he actually wrote, which he didn't. But he wrote the tunes, and they're arranged into the style of the famous 6 Bach Brandenburg Concertos. And we're kind of touching on Brandenburg Concertos today because, as I mentioned to you a little earlier, when we were talking off the radio, that today is the actual 300th anniversary of Bach's submission of those 6 famous works just to a guy that was trying to get a job with, the Margrave of Brandenburg. So he was kind of a big shot there. What was to be that part of Germany in the future. Bach was looking for a gig. So he submitted these 6 pieces that he collected. They didn't write them all together. He submitted them basically as a job application for this group of pieces. And he didn't get the gig. That was his application. The 6 Brandenburg Concertos and Margrave have, well, some of the wisdom. I think it goes that way sometimes. You never know. See what he said. Well, there you go. I mean, maybe there was some bad times. I'm thinking now, sometimes they never write those kind of secrets, right? And these, oh, your hugeness. And he did that. So he wrote this. He really underplayed. Maybe he just good morning to William in Dearborn Heights. Kathy in Rochester Hills. We dropped the news a little earlier, and we were playing some of the lullaby. She wanted to know about the lullaby album. Kathy, that's the 9 CDs, my first classical CDs. And you'll get the lullaby album, you get the Mozart album, you get the Beethoven album, the ballet album, the piano album, the classical music album. yesterday that everything I should see because now the computers are behaving. You went out for coffee, and I was trying to a minute ago, and you know, sometimes those things I know it.
We are on the record calling case number 2014224, First National Bank versus Michael McCullough. This matter is scheduled for debtor's examination today at 11 o'clock. It's now 11:31. Neither party having appeared, debtor's examination is dismissed. We are off the record, and that is the end of the docket for this